Justice Barrett, writing the opinion, makes the court's point very succinctly. We begin and end with standing. At this stage, neither the individual nor the state plaintiffs have established standing to seek an injunction against any defendant. We therefore lack jurisdiction to reach the merits of the dispute. Standing is the only thing the majority of the court even bothered to consider. Then what is standing? It's the legally protectable stake or interest that an individual has in a dispute that entitles him to bring the controversy before the court to obtain judicial relief. So why does the court say that the states of Missouri and Louisiana, not to mention the 5 individuals, do not have a legally protectable interest in the executive branch coercing social media companies to censor information? Under their long-standing content moderation policies, social media platforms have taken a range of actions to suppress certain categories of speech, including speech they judge to be false or misleading. In 2020, with the outbreak of COVID-19, the platforms announced that they would enforce these policies against users who post false or misleading content about the pandemic. The platforms also applied misinformation policies during the 2020 election season. Well, so far so good. Social media platforms have their own content moderation policies. Now, as private entities, they have the right to control what content is hosted on their platforms. However, in 2020, things changed. During that period, various federal officials regularly spoke with the platform about COVID-19 and election-related misinformation. For example, White House officials publicly and privately called on the platforms to do more to address vaccine misinformation. Surgeon General Vivek Murthy issued a health advisory that encouraged the platforms to take steps to prevent COVID-19 misinformation from taking hold. The Centers for Disease Control and Prevention alerted the platforms to COVID-19 misinformation trends and flagged example posts. The Federal Bureau of Investigations and Cybersecurity and Infrastructure Security Agency communicated with the platforms about election-related misinformation in advance of the 2020 presidential election and 2022 midterms. So starting in 2020, several federal officials from multiple agencies, including the White House, encouraged these platforms to take steps to prevent misinformation about COVID-19 in multiple elections. Please keep this in mind because it's going to become very important as we continue through this decision. Respondents are 2 states and 5 individual social media users who sued dozens of executive branch officials and agencies alleging that the government pressured the platform to censor their speech in violation of the First Amendment. Respondents allege that the federal government pressured social media companies to censor their speech. Now, if you're taking notes, this is another important point we'll get back to later. For now, let us continue with the majority's opinion on the case. Following extensive discovery, the district court issued a preliminary injunction. The Fifth Court affirmed in part and reversed in part. The court held that both the state plaintiffs and the individual plaintiffs had Article III standing to seek injunctive relief. On the merits, the court held that the government entities and officials, by coercing or significantly encouraging the platform's moderation decisions, transformed those decisions into state action. The court then modified the district court's injunction to state that the defendants shall not coerce or significantly encourage social media companies to suppress protected speech on their platforms. Now we have an idea of what the judges in the district circuit courts thought. They held that both the state and individual plaintiffs had shown standing to seek an injunction against the actors in the federal government. Now, this was based on their understanding that by coercing and encouraging the platform to make certain moderation decisions, those decisions now became state actions. However, the Supreme Court majority did not agree. Held, neither the individual nor the state plaintiffs have established Article III standing to seek an injunction against any defendant. How did the court come to such a decision?